Your president may easily become king. That's what Patrick Henry warned would happen with the executive branch as structured as it is under the Constitution, but he was far from alone. During the ratification debates, Anti-Federalists repeatedly warned about the structure of the presidency of the executive branch. There wasn't a proper separation of power. There was too much power in too few hands. This would lead to the worst kind of king, an elected monarchy, where people choose a tyrant to rule over them every few years. Sounds pretty familiar, doesn't that? So on this episode, I'm going to go through the primary arguments made by Anti-Federalists in 4 to 5 main categories. I've got one dedicated to just Patrick Henry alone, with quotes and citations from people like Henry, George Mason, Brutus, Cato, Philadelphiensis, and many others, probably a few that we've never heard about in government-run schools. But first of all, welcome, and thank you for joining me here on the Path to Liberty. My name is Michael Bolden with the 10th Amendment Center, and this is the show for Wednesday, July 24th, 2024. I can't thank you enough for spending some of your time with me today. I want to kick it off with just a quick overview from the Center for the Study of the Ratification of the Constitution. They have a nice paper that'll be linked to in the show notes that goes over some of the debates here. And they write that the Americans had considerable experience with executives. They had lived under the British king, who had power to veto colonial acts of legislation before they went into effect. The Articles of Confederation provided for no separate executive. But the Confederation Congress did elect its own president. We hear about them from time to time, but they were not like the executive under the Constitution. It was a president who served more or less as the Speaker of Congress. And they also point out that the states under the Articles each had their own governor or president or magistrate. Most were relatively weak in comparison to their own state assemblies. And we can see how a lot of the states structured their constitution and how they wanted to have an executive to understand how a lot of the Anti-Federalists thought things would be better. For example, here's George Mason and his plan for the Virginia Constitution. He wrote these notes between around the 8th and 10th of June in 1776. It was adopted by the end of June of 76. And the first thing, the plan of government, the first thing he says is let the legislative, executive, and judicative departments be separate and distinct so that neither exercise the powers properly belonging to each other. The primary issue was that the Anti-Federalists really wanted to make sure that these were totally separate. Well, there are a few other issues as well. One of them, for example, was that they wanted more than just a singular executive. That might not even cross our minds as an option. Why would anyone structure a system like this? But most of the state constitutions, or a number of the state constitutions, the revolutionary constitutions enacted after 1776 and before 1787, provided for a kind of a council, a group executive. And George Mason was one of the many people who was in favor of that. Here, for example, from that Virginia Constitution, June 29th, 1776, a governor or chief magistrate chosen annually shall, with the advice of a council of state, exercise the powers of government according to the laws of this Commonwealth. So there was kind of like a CEO, but it was a team decision in many situations. Now, the governor under the Virginia Constitution, from my understanding, elected by the houses of the legislature, not the people at large, was not even given the power to veto legislation and was required to act with approval of the council on many important matters. And you can read, that'll be linked to in the show notes as well. You can read that full revolutionary Virginia Constitution. We also have the Pennsylvania Constitution. In Section 3, the supreme executive power shall be vested in a president and council. This was in September of 1776 when they adopted that one. And so we see this type of thing being brought up in the Philadelphia Convention. Just jumping forward to when they were framing the Constitution, George Mason was there as well. There was some debate over whether or not to have a plural executive or a singular executive. And here this is June 4th, 1787, there was a question for a single executive. It was agreed to by Massachusetts, Connecticut, Pennsylvania, Virginia, North Carolina, South Carolina, and Georgia. Basically, 3 states voted no. It was New York, Delaware, and Maryland. So this was rejected pretty quickly at the Philadelphia Convention.
But George Mason wasn't happy about that. And he points out that we are, Mr. Chairman, this is on the 4th. He missed that vote, but he pointed that he was voting no. It was a divided vote, but Virginia ended up being on board, from my understanding. We are, Mr. Chairman, going very far in this business. We are not indeed constituting a British government, but a more dangerous monarchy, an elective one. We are introducing a new principle into our system, and not necessary, as in the British government, where the executive has greater rights to defend. Do gentlemen mean to pave the way to hereditary monarchy? Or an elective one, I guess. And so during the ratification, or during the framing of the Constitution in the Philadelphia Convention, before it got to the states for ratification debates, they didn't actually come up with any plan to expand it beyond a singular executive. Benjamin Franklin on the Federalist side certainly was opposed to this as well. He warned on that same day that because of this singular executive, he warned that the executive would always be increasing here as it does elsewhere until it ends in a monarchy. So there were some people on the Federalist side who didn't like that approach either. And George Mason, talking in his objections to the Constitution, this was first written right at the end of the Philadelphia Convention on the back of some notes from one of the committee. He wrote it again and started handing it out to people, mailed it to George Washington just after the Philadelphia Convention, September 18th or so, and then it started getting published without his permission. And here's how he put it. This is one of his first objections, is the President of the United States has no constitutional counsel, a thing unknown in any safe and regular government. He will therefore be unsupported by proper information and advice, and will generally be directed by minions and favorites, or he will become a tool of the Senate. So one of George Mason's primary objections that were published, and he did stand by them as well. He just wasn't happy with the fact that they were published without his permission, but he took the position that, well, what you're going to have is a guy who nominates people to be in various positions of power, to head various offices, etc. And they were just going to be his minions. They're going to be yes men. And so that wouldn't actually check his potential power. He wanted it to be a council, just like we saw in a number of the state constitutions. So that's the first issue. The second one was that the second issue that they had was they felt that the executive power was too far blended with the other branches. This primarily was with the Senate, for example. And all the founders, whether it was Federalists or Anti-Federalists, they cited what James Madison, for example, called the celebrated Montesquieu, who wrote The Spirit of the Laws in 1748, was highly influential on constitutional structure in the founding generation. And we see here one of these quotes from this, from Montesquieu's Spirit of the Laws. When the legislative and executive powers are united in the same person or in the same body of magistrates, there can be no liberty, because apprehensions may arise lest the same monarch or Senate should enact tyrannical laws to execute them in a tyrannical manner. So if you're passing the laws and then you're executing the laws, if you're involved in the same type of stuff, then you're going to end up with tyranny. You're going to have no liberty whatsoever. And he continues, again, there is no liberty if the judiciary power be not separated from the legislative and executive. Were it joined to the executive power, the judge might behave with violence and oppression. And we see a number of anti-federalist writings citing Montesquieu. They mention him specifically by name a number of times. Otherwise, they mention the same principle. For example, Mercy Otis Warren, in her observations on the new Constitution, she wrote this under the pseudonym A Columbian Patriot. The executive and the legislative are so dangerously blended as to give just cause of alarm, and everything relative thereto is couched in such ambiguous terms, in such vague and indefinite expressions, as is a sufficient ground without any other objection for the reprobation of a system that the authors dare not hazard a clear investigation. So she's basically saying the combination of what she sees as a blend of the executive and legislative powers, and I'll get to a couple of ways that the Anti-Federalists saw that in just a moment, plus vague and indefinite terms. I mean, we know things like general welfare, necessary and proper. We can understand the actual legal meaning of those terms and phrases,
But she recognized, like so many other anti-federalists, that people with power, when they're given something that can be read in multiple ways, they're going to read it in the way that expands their own power. So she says this combination of stuff in and of itself was enough to reject the Constitution. That was her view. Now go back to George Mason. He has this take as well. He said, from this fatal defect, this blending of legislative and executive powers, has arisen the improper power of the Senate in the appointment of public officers. And the alarming, so he's saying that the Senate is blended. This is a legislative power. They're representing the states for legislative power, but they're still partly blended with the executive branch, and he doesn't like that. He thinks they need to be completely separate. The Federalists, I'm not going to make all the Federalist rebuttals to this. I'm just going to present with you primarily the Anti-Federalist take, but just a quick aside, they basically took the position, Madison specifically, that it didn't need to be completely separated. We could do an episode on that if you find it super interesting at some point. From this fatal defect, wrote Mason, has risen the improper power of the Senate in the appointment of public officers, and the alarming dependence and connection between that branch of the legislature and the supreme executive. Hence, also spurring that unnecessary officer, the vice president. I can think a few of those in recent years that I would have been great to just do away with. We don't need these people. But that's what Mason called it. He thought that the vice president was a completely unnecessary officer. This was his edition published November 22nd, 1787. He did expand on his original arguments, his objections to ratification. Anyways, the unnecessary officer of the vice president, who for want of other employment, get a job, is made president of the Senate, thereby dangerously blending the executive and legislative powers, besides always giving to some one of the states an unnecessary and unjust preeminence over the others. And if we think about the notion that the states were supposed to be represented, well, they weren't equally represented, but they were supposed to be represented in Congress equally. At least they were set up that way in the Senate. And if you have a 25-25 tie between a two-party system, even though the founders didn't like that, but they recognized these types of things would happen, then the vice president is giving an additional weight, a 26-25, a tie-breaking vote. He did not like that because this was part of the executive branch participating in the legislative branch. And he continues, he said, by declaring all treaties supreme laws of the land, the executive and the Senate have, in many cases, an exclusive power of legislation, because the executive comes up with these ideas and the Senate ratifies the treaty, and that gives them, in certain cases, total legislative power. And again, he sees that as dangerous blending of the powers, violating the principles that everyone agreed upon under Montesquieu. Here from Sentinel in his second Anti-Federalist paper, this is October 1787, points out again the President General, this is how he refers to him, the Commander-in-Chief, they kept calling him the President General, is dangerously connected with the Senate. His coincidence with the views of the ruling junto in that body is made essential to his weight and importance in the government, which will destroy all independency and purity in the executive department. And having the power of pardoning without the concurrence of a council, he may screen from punishment the most treasonable attempts that may be made on the liberties of the people when instigated by his coadjutors in the Senate. That's Sentinel in his second Anti-Federalist paper. Now, the Impartial Examiner, in a number of places, actually felt that the veto power itself was a blend of executive and legislative power, because if the legislative branch is supposed to have the power to legislate and the executive branch is not supposed to have the power to legislate, then they're making a determination on a veto, even if you can override it, that they're having a say in what legislation is going to be passed. He felt that this type of a system was only proper in a monarchy, and basically made the case like, look, if we're going to have this power, we should make it a monarchy. And this is how he put it. This mixture of the legislative and executive, moreover, highly tends towards corruption. The chief improvement in government in modern times has been the complete separation of the great distinctions of power, placing the legislative in different hands from those who hold the executive, and again severing the judicial part from the ordinary administrative. And then, of course, he goes right into specifically citing Montesquieu on legislative and executive powers. And he puts it like this. Actually, who was that from? I don't know if that was Impartial Examiner. That was Sentinel number 2 right there, actually. The previous was the dissent of the minority of the Pennsylvania Convention in December of 1787. So here's Impartial Examiner talking about the veto power blending in the legislative and executive powers. In a monarchy where the established maxim is that the king should be respected as a great and transcendent personage who knows no equal, who in his royal political capacity can commit no wrong, to whom no evil can be ascribed, in whom exists the height of perfection, who is supreme above all and accountable to no earthly being, it is consistent with such a maxim that the prince should form a constituent part of the legislature. He's saying in that type of a situation, when you have this all-powerful person who can do no wrong, the monarch of a country, well, of course they should be part of the legislature because they're going to have final say over everything. To this end, he writes, the King of England is invested with the sole executive authority in a branch of legislative jurisdiction so far as to pass his negative on all proceedings of the other 2 branches or to confirm them by his assent. So taking the idea of just the veto power, Impartial Examiner is also saying affirming a piece of legislation passed is blending the executive with the legislative power. And he says, let the free citizens of America, consulting their true national happiness, wish for no innovation but what is regulated according to the scale of equal liberty, or which may not destroy that liberty by too great a share of power being lodged in any particular hands. Let this collateral jurisdiction, which constitutes the royal negative, be held by kings alone. Now, I know for a fact that James Madison, at the beginning of the Philadelphia Convention, proposed with Edmund Randolph and a few others something called the Virginia Plan. And he wanted in that the central government, the new general or federal government, not necessarily in the hands of a king, but whether it was Congress or something, he wanted the federal government to have power, a veto power over the states in all cases whatsoever. And they were calling it the royal or kingly prerogative. They recognized that a veto power was a kingly prerogative on the Federalist side as well. And this is what Impartial Examiner is saying here as well. Let this collateral jurisdiction, which constitutes the royal negative held by kings alone, since with kings it first originated, let this remain in its native soil as most congenial to it. There it will cumber less and be more productive. Here it will be an exotic and may poison the stock in which it may be engrafted. So in other words, let's reject all forms of kingly power here. We don't want it. That's the Anti-Federalist take. Now, next up in these categories is that there's just too much power. Too much power if you're thinking about the idea that it's going to be a single executive rather than a council, and then they kind of have a blending of legislative and executive power, and then on top of it, it's just, there's all kinds of stuff that they're authorized to do. They're saying this is just too much power for one person to have. And here's Cato in his 4th essay in November of 1787. He said, the deposit of vast trusts in the hands of a single magistrate enables him in their exercise to create a numerous train of dependents. This tempts his ambition, which in a Republican magistrate is also remarked to be pernicious, and the duration of his office for any considerable time favors his views. Give him the means and time to perfect and execute his designs. We see, for example, that in the Virginia Constitution, it was elected annually. I don't think I can handle the most important election of our lifetime every single year, but this was certainly the Anti-Federalist take here. Cato continued, he therefore fancies that he may be great and glorious by oppressing his fellow citizens and raising himself to permanent grandeur on the ruins of his country. That's what Cato predicted we would have under a single executive. And Brutus, in his first Anti-Federalist essay, had a very similar take. A large country with one person in charge is going to have a bunch of people who are kind of yes men working for him. And the result is this. In so extensive a republic, the great officers of government would soon become above the control of the people and abuse their power to the purpose of aggrandizing themselves and oppressing them. And he continued with this, talking specifically about executive power. The trust committed to the executive offices in a country of the extent of the United States must be various and of magnitude. And this was at a time, of course, when in comparison to today, that the power delegated under the Constitution was seen as way, way less. It's not even close. If you're looking at a system where they were only going to have few and defined powers, as James Madison described it in Federalist number 45, and everything else reserved to the states would be numerous and indefinite, the people of the states. Yet, and even though there was a small size in geographic size in comparison to what we have today, even in that situation, we're getting a warning from Brutus that, you're going to have a lot of power, various and of magnitude in the executive offices. He said the command of all the troops and navy of the republic, the appointment of officers, the power of pardoning offenses, the collecting of all the public revenues, and the power of expending them, with a number of other powers, must be lodged and exercised in every state in the hands of a few. He's not saying it must be as in it's a good idea. He's saying that's how it's going to play out. You're going to have a lot of power in just a few hands. And then he points out that because of all that power, the people who are drawn to those positions of power would be the most ambitious and designing men. And he said such men will be ever relentless, or ever, I guess that's a good term for it. He said such men will be ever restless in their pursuit after them, these powers, proper objects for ambitious and designing men. He said they will use the power when they have acquired it to the purposes of gratifying their own interest and ambition. And it is scarcely possible in a very large republic to call them account for their misconduct or to prevent their abuse of power. Whether they were right or wrong on how you would structure an executive branch to prevent this type of thing, they certainly said things that feel pretty familiar today, don't they? I mean, at least for my entire life, this is a pretty good description of a lot of what we see. And they aren't ever held to account. These executives really are never held to account. They're never held responsible for the wrongs they do to our liberty, to our prosperity, to our property, to the Constitution, to their oath. So there's something to that. Here's Cato again. He said his eminent magisterial situation will attach many adherents to him, and he will be surrounded by expectants and courtiers. So in other words, you're creating a scenario that even though you're not calling it a monarchy, you're creating kind of an imperial court. I see a lot of those people today. His power of nomination and influence on all appointments, the strong posts in each state comprised with his superintendents and garrisoned by troops under his discretion, his control over the army, militia, and navy. We could also add today the other kind of standing army, militarized federal agencies, so many of which shouldn't exist, that are armed to the teeth, like a military force. Cato continues, the unrestrained power of granting pardons for treason, which may use to screen from punishment those whom he had secretly instigated to commit the crime and thereby prevent a discovery of his own guilt. His duration in office for 4 years. They thought that was a problem. They wanted annual elections, biannual at most. He said these and various other principles evidently prove the truth of the position that if the president is possessed of ambition, he has power and time sufficient to ruin his country. There are many examples of presidents with ambition and love of power over the years who've done much to ruin the structure of the Constitution, and I would say ruin the country from what it's supposed to be. Here's an old Whig on this line as well. He said, in the first place, the office of President of the United States appears to me to be clothed with such powers as are dangerous, to be the fountain of all honors in the United States, commander-in-chief of the army, navy, and militia, with the power of making treaties and granting pardons, and to be vested with an authority to put a negative upon all laws, unless 2/3 of both houses shall persist in enacting it, and put their names down upon calling the yeas and nays for that purpose, is in reality to be a king as much as a king as the King of Great Britain, and a king too of the worst kind, an elective king. He said the election of a king, whether it be in America or Poland, will be a scene of horror and confusion. That is a pretty good description of our election process in modern times. You've got someone who is vying for the top office of the largest government, the most powerful government in the history of the world. It's basically what my friend Tom Woods for many years has called a low-grade civil war, where you've got one side trying to control the other side, to dominate the other side in order to get their person, their team in power, even if they don't like who they are. But this was the prediction from an old Whig in November of 1787. And while I'm here, I want to take a quick moment and mention that all of these original source documents, I'm only citing pieces of it, but I think I'm trying to do my best to tell the big picture here. Take different pieces from different anti-federalist writers that show the same kind of a message. We can, of course, read in more detail on that. And we have a blog post for every single episode that gets published about 1 to 3 hours after the live stream is done here in the morning. Alan Mosley does an awesome, super consistent job on getting that done. I'm so grateful for him working with us on this. So he'll get that organized, and on each blog post for every single episode, you're going to find a show links section when you scroll down, and all the stuff that I mentioned in the episode should be there, linked to, so you can read, learn more in context on your own time. You're also going to find all the various platforms we're on. We live stream on the mainstream ones, like, of course, there's YouTube and X and LinkedIn and Facebook and probably a few others. But we also live stream over at rumble.com and odyssey.com. I'm so grateful for everyone who joins us, whatever platform works best for you. If we're missing from one, I want to be on all the platforms possible. So but while I'm here, let's say a quick hello to everyone out in the live chat, or as many people as I can. There's Dennis and Gypsy and Brewster and Gringado and a few others over on Rumble. Let me take a look over on Facebook and YouTube. There's Jug and Charles, Melody, Senator DT, glad you could make it for a live one. Diana, good to see you. Joshua, there's Lee Deming over on LinkedIn, never held to account. That is a very important point. I know I'm skipping over a few people here, but I appreciate you being here. I will read through the comments a little bit later today. I get a lot of great ideas from your comments, questions, things challenging, things that I'm pointing out, ideas and suggestions for future episodes. You can also email team@10thamendmentcenter.com. I read through almost everything every single day. I don't get a chance to respond to too much of it, but I appreciate your feedback and I appreciate you being here. Don't forget to leave us a review on Apple Podcasts or any other podcast platform. Smash the like on any of the video platforms, leaving comments. All these things can trigger the algorithms and tell them to show us to more people. So if you're learning something from this episode, please go ahead and take one of those actions because it does help us out. So next up on this list, so we're talking about, first of all, separation of powers. They thought the powers were too blended. They wanted to have a council rather than a singular executive in most situations. Now, there was some disagreement between people on this. And of course, like I pointed out, even Benjamin Franklin on the Federalist side wanted a council. So it wasn't just clear-cut lines in the sand. There was too much power in a single person. And then this would, of course, tend towards a monarchy. Now, before getting to the warnings that it would end up as a king, even if it was an elective one, just like the old Whig said just before that break there, Luther Martin, who was at the Philadelphia Convention, he walked out in September. I think it was like maybe a week or so before the end of the convention. But he wrote here in Genuine Information number 9, his papers are pretty awesome to check out, January 29th, 1788. He wrote that there were people at the convention who actually specifically wanted to make the executive a king. And I'm not sure where, we'll have to trust his judgment on this. I can't verify for sure that he's referencing Madison's comments, for example, on the Virginia plan. Now, Madison gave that up and he didn't push for that after the ratification debates got underway, but that's what his original goal was. We know for sure that Alexander Hamilton wanted something like that. He made a long speech talking about his plan for government. Basically, he said, if we could get away with it, we should get rid of the states even completely. We don't want federalism. We want just, a powerful executive to do, and central government to do everything. But here's Luther Martin. He said, there was a party, he's referencing the Philadelphia Convention. There was a party who attempted to have the president appointed during good behavior, without any limitation as to time. And not being able to succeed in that attempt, they then endeavored to have him re-eligible without any restraint. It was objected that the choice of a president to continue in office during good behavior would be at once rendering our system an elective monarchy. He thought just having them re-eligible and then appointed, this was a form of an elective monarchy. And he continued, he said, it was reported by the Committee of Detail the choice was to be made by ballot in such a manner that the states should have an equal voice in the appointment of this officer, as they of right ought to have. But those who wished as far as possible to establish a national instead of a federal government made repeated attempts to have the president chosen by the people at large. He felt that the people who wanted a centralized kind of a new version of a British system, an elected monarch, someone with a strong hand to rule over the people and make sure that they have liberty, he thought the people on the nationalist side, rather than a confederation or a federalism system, a federal side, they wanted to have the president elected by the people at large. So he supported that effort to have the president appointed by Congress in such a way that the states would have an equal voice on it. So one state, one vote. That's it. Not one person, one vote. That was Luther Martin's approach. Here's Philadelphiensis in his 9th Anti-Federalist paper. Also will be linked to in the show notes. He said, "Who can deny but the President General will be a king to all intents and purposes, and one of the most dangerous kind too, a king elected to command a standing army?" He said, "Thus our laws are to be administered by this tyrant." He thought just having the system as it was made anyone in office a tyrant. If we think about some of the principles of the American Revolution, as cited by John Dickinson, for example, in his Letters from a Farmer in Pennsylvania, the most widely read documents on American liberty till Thomas Paine's Common Sense in 1776, these were very influential. Dickinson specifically said, who are a free people? It's not those who happen to live under a government that is equitably and reasonably exercised. It's when they live it. So if they have a bunch of power and they just happen to use it in the right way that doesn't violate your liberty, you're not a free people. He said that's really basically just luck. You just happen to be in a good situation. The people who are free are in a situation where a government is so constitutionally checked and controlled that as soon as they get out of hand, as soon as they go beyond the limits, they're immediately slapped back in. That's my paraphrase of what Dickinson had to say. But we can see a similar take here with Philadelphiensis in the Anti-Federalist writings, because soon as this person takes office, they are a tyrant. He said, "Thus our laws are to be administered by this tyrant, for the whole, or at least the most important part of the executive department is put in his hands." And his next paper a couple of weeks ago, again referring to him as the President General, who is to be our king after this government is established, is vested with powers exceeding those of the most despotic monarch we know of in modern times. Now, again, Federalists had responses to all of this, and if you're really interested in hearing the Federalist side, the responses to these Anti-Federalist takes, I would definitely be open to doing an episode covering their take. And that way we can compare the two, and you can decide then from there if you think one side was right or the other, or maybe a little bit of both. I tend to think a little bit of both. Here's Tammany in the Virginia Independent Chronicle, January of 1788. Though not dignified with the magic name of king. I like how he wrote that. Though not dignified with the magic name of king, he will possess more supreme power than Great Britain allows her hereditary monarchs, who derive ability to support an army from annual supplies and owe the command of one to an annual mutiny law. The American president may be granted supplies for 2 years, and his command of a standing army is unrestrained by law or limitation. So he's saying just in those areas, now of course Federalists disagreed, but just in those areas he gave an example of how he saw the king, whether called that or not, without the magic name of a king, having more power than the monarchs of Great Britain, which they fought a long bloody war to get away from. And the thought process is basically, if we fought to get away from this, why would we be so dumb as to establish something the same or the worse? So that's the most recent section. And the last category I want to cover is just some quotes from Patrick Henry that I think that ties this all together. All from the Virginia Ratifying Convention, which is in June of 1788. Here he is saying, "There is to be a great and mighty president with very extensive powers, the powers of a king. He is to be supported in extravagant magnificence, so that the whole of our property may be taken by this American government, by laying what taxes they please, giving themselves what salaries they please, and suspending our laws at their pleasure." So for Patrick Henry and many on the Anti-Federalist side, many on the Federalist side, especially before ratification debates, the notion of decentralization, the right to local self-government, being able to have the people themselves in each state, in their own area, make the decisions of what laws they're going to have in their area. This was essential to liberty, because if you tried to have a one-size-fits-all solution, you really are going to end up with a one-size-fit-none, and you're going to end up with a situation based on factions trying to control the one-size-fits-all power, violence, force, etc. Because if you can't allow people to live their own way in their own area, which is the basis of the 10th Amendment, what Thomas Jefferson called the foundation of the Constitution, that's what you're going to end up with. Real problems. In essence, suspending our laws at their pleasure. He said, again, your president may easily become king. You've given him way too much power in this, said Patrick Henry. He talks about some of the ways. He said the important right of making treaties, which we heard from others earlier, is upon the most dangerous foundation. The president, with a few senators, possess it in the most unlimited manner, without any real responsibility, if from sinister views they should think proper to abuse it. Now, of course, we can take the position that under the Constitution, they're not authorized to make a treaty that violates anything in the Constitution. But yet, the people with power, the senators and the executive branch, certainly take the position that they can sign onto treaties that undermine various parts of the restrictions in the Constitution, Second Amendment, for example, other parts of it. Going further, Patrick Henry says his political character is but transient, and he will promote as much as possible his own private interests. He will conclude the constant observation has been that he will abuse his power, and that is expected. If anything, we could disagree with every single way the Anti-Federalists said the executive branch should be structured. We could disagree with every single way the Federalists said the executive branch should be structured. We could want a totally different approach or none whatsoever. But it is hard to disagree with the fact that Patrick Henry absolutely called it with this one. He will abuse his power, and that is expected. He said, if your American chief be a man of ambition and abilities, how easy it is for him to render himself absolute. Like I've been thinking on almost every episode, I'm not sure who needs to hear this message, but I think we really all do. Whether we're already on board with this type of thing or not, whether we've studied or not, it's essential to reiterate what people had to say about the structure of the Constitution and how things would play out so we can understand maybe what needs to be done about it today. That's why we work so hard every single day to get this important foundational information, whether it's from the Federalists, the Anti-Federalists, from the American Revolution, strategy of how to defend the Constitution when the government refuses to follow the rules, which is 24/7, 365. Nothing helps us do this work more every single day, more than the financial faith and support of our members. If you got a couple of bucks of that dirty government fiat, please consider throwing it our way. Our membership program starts out at just $2 a month over at 10thamendmentcenter.com/members. Again, 10thamendmentcenter.com/members. We also have annual, 5-year, and lifetime options. I'd be very grateful for any consideration you can give to joining us as a member today. but no pressure. If you can't afford it or if you're just not ready, that's cool. You can also, as I mentioned earlier, you can help us spread the word by leaving comments, leaving reviews on Apple Podcasts, smashing the like button, things like that will definitely help us out. And if you want to make a one-time donation, 10thamendmentcenter.com/donate. Again, I really appreciate you spending some of your time with me today. I hope you enjoyed this episode as much as I enjoyed putting it all together and sharing it with you. I hope you learned something. That's more important than anything. And I hope to see you next time here on the path to liberty.